have your opponent up yet.
Sorry,
That's okay.
I jumped the gun.
You know, eager to do it. I got the adrenaline's pumping. I know how to do it. Do we have Mr. Husby? There he is. There you go. Hi, Mr. Husby.
Good morning.
All right. How about it, Mr. Tackenberg?
All right, from the top. Good morning. May it please the court. My name is Brian Tackenberg from Crabtree and Auslander on behalf of the appellant. I would like to reserve 5 minutes for rebuttal, Your Honor.
Sure.
So this is an appeal from an order granting Trench Training's motion to dismiss Thomas's premises liability claim with prejudice. There are two issues on appeal. The first is we believe that Thomas pled a viable negligence claim in his third amended complaint. And second, if the court disagrees with that, we contend that the judge abused its discretion by denying Thomas leave to amend. Obviously,
Mr. Tackenberg, let me just jump right in and let's see if we could, let's look at the allegations that you set forth in the complaint. And it's interesting reading through what the judge was interjecting, and in terms of what the judge was under the impression that you somehow it was wrong to allege alternative pleading, alternative causes of action. So let's get to the operative complaint in this case. And help me out. Number one, you did allege that JT was a business invitee of Trench, correct?
yes, ma'am.
All right. And then you also allege that JT got a receipt from Trench for training services. That's also alleged, correct?
That's correct, Your Honor.
All right. And then you've also alleged that Trench had an agreement with the landowner to provide training services to athletes on the premises, correct?
That's also correct, Your Honor.
All right. And then you allege that he was on the premises being trained by Trench, correct?
Correct.
And then before the injury, and this is, and I quote, Trench had negligently installed and maintained the synthetic turf located in the portion of the space it was using to train athletes such as JT that eventually caused injury to JT, correct? That's in there.
Correct, Your Honor.
And then next, I'm going through, and then another this same thing that says that Trench's employee negligently instructed JT to train on the synthetic turf, even though the employee knew or should have known that the turf had holes in it, had not been properly installed, maintained, nor probably fixed to the floor, constituting a dangerous condition. You have that allegation there as well, correct?
Yes, Your
And
Honor.
then you also mentioned that Trench owed JT several duties to maintain property, train its employees, warn and correct of dangerous condition. And finally, that there was a breach of these duties by either failing to install, maintain, and warn. So I'm puzzled. That seems to me that you've alleged a cause of action. What was the judge's ruling and not finding that what was missing in there?
Well,
that
you
judge articulated.
You have gone through my intro better than I did. What actually happened was, so the judge, I think it just came down to confusion. The judge did not think that Thomas could make, alternative allegations as to who controlled the property. So
I have a question for you.
Yes, ma'am.
One of the things that it seemed to me was troubling the judge or your opposing counsel was that the way the complaint was amended, the way the third amended complaint had been amended, which was to limit the number of incorporated allegations. The last incorporated allegation was to the effect that somebody else had installed the AstroTurf. And then the allegations pertinent to count one against Trench include an allegation that Trench had installed the AstroTurf. So both can't be true, I don't think. And one of the heartburn areas here had been that those two allegations, this wasn't an alternative theory pled it was an internally inconsistent theory. Can you address that?
Sure, absolutely. So there's actually a couple of different responses to that, Your Honor. First, we cite a case called Johnson v. I think Department of Health, where a plaintiff pled mutually exclusive facts, only one of which could be true, in one count. And this court said, it may not be ideal, you probably shouldn't do it, but it's not a basis on which to dismiss a complaint. So, I think there is some confusion about alternative pleading and whether they can be included in the same count. And I think they can under this court's precedent. I think you can include alternative factual allegations within a count.
So if we accept that, then this complaint stated a cause of action, at least bare bones under your theory. But the other part of your appeal is that the trial judge disagreed and dismissed with prejudice despite the request to amend. And I had a couple of questions for you on that. This was one of the areas I think that was confusing. The complaint was originally filed and Trench answered it.
That's correct.
And then another defendant moved on jurisdictional grounds and the complaint was amended and Trench then moved to dismiss. But I think that the net effect of the times that the complaint was amended vis-a-vis Trench was twice, as opposed to this being really the fourth operative complaint against Trench.
Right, Your Honor.
And you kind of made that argument in your briefs, but I thought that the trial judge was sort of looking at the 3-strike rule in, an absolute sense. And so the other part of that, because I'm just curious about the denial of leave as whether the trial judge abused his discretion, the trial judge's main focus on prejudice seemed to be that the case was a few years old and that the trial judge was concerned about complying with the Supreme Court's case management standards and felt that this case was too old, it's too late. But isn't prejudice to be viewed more from the perspective of whether the defendant can defend based on its understanding? Does the defendant have time to formulate a defense? Can the defendant legitimately defend? As opposed to, it's just been too long.
Right, Your Honor. I mean, we cite a case from this court called, I think, Drish, that says the prejudice prong is really only looked at through the prism of, does the amendment prevent the defendant from being able to defend the case? And that was certainly not the way the judge looked at it in this case. The judge looked at it as 3 years is just too long. And interestingly, we cite a very recent decision from the 4th DCA in our reply brief, at the very tail end of the reply brief, where a trial court made the same ruling. He said, this case has just been around too long. It's going to prejudice the defendant by allowing an amendment. And the 4th DCA said, no, that's not a proper basis upon which to find prejudice. So Your Honor is completely correct.
And my understanding of the authority regarding the permission to amend is that we look at it would be an abuse of discretion unless refusal to permit amendment would be an abuse of discretion unless, number one, the privilege to amend has been abused. 2, the amendment would be futile, or the amendment would prejudice to the other party. What's interesting, under this record, the court never articulated any of these things. And as Judge LaBritte said, the judge just simply jumped in and said, this case has gone on too long, 3 years. And I could appreciate from Mr. Hugsby, from his standpoint, it's like, well, my client is a small business, this is too long, but it doesn't take away from the analysis that the court had to consider. That's if we get to the point whether or not your complaint fails to state a cause of action. So let me flip to that, Mr. Tackle, because I want to be able to nail this. Was part of the confusion of the trial judge's conclusion that you failed to state a cause of action because of the incorporation of by reference of the complaint? Because in your operative one, because there was some, if you look at the dialogue between your opponent at the hearing and the court, at one point, your opponent said, Judge, he incorporated by reference all the allegations of his complaint. He can't do that. He can't do that. And I think there was some trying to do some clarification, but the bottom line is, if you look at the operative complaint, as I read it, and correct me if I'm wrong, your paragraph 30 just says that JT incorporates by reference only paragraphs 1 through 6 and 29, not everything that appeared to be the problem that, from what I'm able to read at the record, that the judge was going into. Am I reading this correctly?
That's correct. So a little bit of history makes that clearer. So with the second amended complaint, paragraph 30, I don't know if the numbers exactly matched up, but the first paragraph of the count against Train's training, the second amended complaint incorporated all the general allegations. And within those general allegations, you know, there are some allegations, alternative allegations, albeit, but there are some allegations that, you know, D1 controlled the space, the AstroTurf and the like. So after the second amended complaint was dismissed, trial counsel made a concerted effort, you know, to make sure that the alternative allegations were being pleaded separately. So instead of incorporating all of the general allegations, he limited it to the first 6, which I believe are jurisdictional, and then 29, and then everything else is in count 1. There was confusion at the hearing, at the motion to dismiss hearing, because I think counsel for Trench Training made an argument at the outset of the hearing that we had incorporated all of the allegations proceeding, as we had in the previous complaint, but not in the third amendment complaint. So I think that's where that confusion comes from as to the alternative allegations.
Thank you, sir.
You know, I just want to jump back to one thing related to Judge Libritz's question that I didn't get to cover, and I just want to cover it quickly. You know, if the court were to find that the incorporation of paragraph 29, which includes an allegation that D1 installed the turf, if the court were to find that the incorporation of that specific allegation within count 1 somehow eviscerated our ability to allege in the alternative, I think it's important to look what paragraph 29 actually says and the extent of what we would be barred from arguing. So if you were to look at page 29, it says, Trench Trainer Thomas began to do some back pedals. A defective and worn area of the multi-layered turf purchased and installed by D1 shifted and caused JT to sustain serious bodily injury. Importantly, you know, if the court were to reach this issue, it only speaks to installation, does not speak to control. It does not speak to maintenance. It does not speak to whether they had the ability to warn of this issue. It's just installation. So even if the court were to
so part of what you're saying is, if we were to, I think what you're saying is, if for whatever reason we found that incorporation was problematic, then go to leave to amend, right?
Well, I think you should always go to, that's the firewall, right, Your Honor? That's where we think we should go if you do think this complaint is insufficient. But my point as to the incorporation of paragraph 29 is, there are multiple breaches that we allege. We allege faulty installation. We allege faulty maintenance. We allege failure to warn. So paragraph 29 really only reaches installation. It doesn't cover anything else. So even if that paragraph were antithetical to our claim and the court finds that we shouldn't be allowed to plead in the alternative, we still would be allowed to proceed on the maintenance claim as well as the duty to warn. So I just wanted to sort of clarify the scope of that allegation. But unless the court has any further questions of me, I will keep my time for rebuttal.
Thank you, Mr. Teckenberg. Mr. Husby, you're up.
Good morning, Your Honors. I hope you can hear me all right. And I will address the case as follows. I listened carefully to how the facts were set forth as to Trench, and I just want to take the court briefly through how we got here, which is the case was filed back on July 12, 2019. There was an initial complaint, and then on August 5th, 2020, without leave to amend, the appellant filed an amended complaint. And that case proceeded against D1 Training Inc., Will Bartholomew, D1 Training Inc., Tampa, and Scott Taylor, as well as the defendant Trench Training. Then on November 9th, 2020, the trial court dismissed that amended complaint in total, and they received leave to amend. And on November 23rd, 2020, there was a second amended complaint filed, which named various defendants, some of which were different, including Trench Training, D1 Sports Franchise LLC, Will Bartholomew, D1 Training Inc., Tampa, and Taylor Scott. Then on January 26, 2022, the lower court, trial court, granted a motion to dismiss the second amended complaint and afforded another opportunity to amend. That's the third amendment. And on February 10th, 2022, the third amended complaint was filed alleging D1 Sports Franchise LLC, Will Bartholomew, D1 Training Inc., Tampa, and Taylor Scott, and the appellee as defendants again. And one of the issues the trial court took with the third amended complaint was the convoluted nature of the complaint, which the court noted didn't contain allegations of ultimate fact, but were conclusory. The trial court felt that the allegations against Trench Training were conclusory, and therefore did not.
With that, Mr. Husby, and I think that's why I went through my questioning to Mr. Tanwa at the beginning, and the same thing and I wanted mainly to alert you, because I know what the court thought it was conclusory, but when I was reading the allegations that they've alleged, every single one, how can the court come to the conclusion that these are conclusory? You know, all you have to do is to allege a duty, a breach, causation, and damages. And by going through, it indicated the position. He was a business invitee. He got a receipt for training services. He had an agreement with the landowner. He was on the premises. Before the injury, there was a negligent installation, and going through all that. So the only thing that I could gather in reading through the transcript is that the judge it was argued to the court that all of the allegations were incorporated all together, that it was an absolute mess, and somehow the court kind of followed that. That's how I could gather, but help me out.
Yes, that's where I was getting to just now, Your Honor. Thank you for the inquiry. The first 6 paragraphs of the third amended complaint, which is in the record 556 to 570, are directed to the appellee Trench. Those are really only jurisdictional and address, residence and type of entity allegations, the intro allegation standard in a complaint, and where does the appellant reside, that sort of thing. In the general allegations, there's one allegation against Trench Training, and that's in paragraph 29, as Your Honor correctly pointed out. And but that says more than the back pedals. It basically, the allegation is that appellant began some back pedals. It doesn't say in that paragraph that he was negligently instructed to do back pedals. He began to do back pedals. Back pedals are not in and of themselves negligence. It doesn't say it's negligent. And in that paragraph, it says, quote, a defective and worn area of multi-layered turf purchased and installed by D1 Sports Franchise LLC, which is defined in the complaint, in the third amendment complaint as D1, and shifted and caused JT to sustain bodily injuries. In that paragraph, appellant doesn't allege that the back pedals were negligent, and they specifically allege that it was the shifting of the turf purchased and installed by D1 Sports Franchise, which caused appellant's alleged injuries. Now that paragraph is incorporated into count 1. Other than that, the paragraphs, and I know Your Honor went through as if the allegations in paragraph 1 applied directly to Trench. And in many of the paragraphs in paragraph 1, I think a rereading will show that many of these allegations are directed to other entities, not other persons and entities, not Trench Training, for
Well,
example.
the allegations that are in the count,
Mhm.
at least twice, as your friend on the other side has pointed out, include an allegation that's not in 29, which is negligently maintaining the turf. What's your position on that? That's different than what was alleged as to D1, and it's not implausible, is it?
Well, it is because you cannot have, our position is that it directly contradicts the paragraph 29, and also directly contradicts that in paragraph, I think it's 34, in and around March 5, 2019, Powerhouse, who's not a party to the case, and Trench is not defined as Powerhouse, was in legal possession of and operating a physical training business gym at the facility located at 3251 West Hillsborough Avenue, Tampa, Hillsborough County. So that is the second allegation within the same count against Trench, which also contradicts the D1 purchase and install allegation in paragraph 29. And the rest of the allegations, for example, Your Honor, indicate, say, prior to the date of the incident, this is paragraph 31, an entity known as D1 Sports Training, hereinafter referred to as D1 Sports, through its owners, Taylor Scott, Karen Scott, hereinafter Karen, marketed to and solicited a business from JT, from the plaintiff, the appellant, as a parent agent of D1. That doesn't have anything to do with Trench. The next paragraph, paragraph 32, it refers to Powerhouse and D1 without reading it. I mean, it refers to D1 Sports, Taylor, Karen, and D1 Training. Doesn't apply to Trench. And where they get into the physical training, there's no allegation of duty or breach of duty on the part of Trench, and there's no allegation of ultimate facts in what did Trench do that was negligent? What did Trench do that breached a duty?
How about paragraph? Okay, let's just jump to paragraph 41. And this is where, and to follow up with what Judge LaBrite said, there's allegation that Trench, the maintenance part of it. And then in paragraph 41, it alleges that Trench's employee negligently instructed JT to train on the turf, even though they knew or should have known that it had holes in it, had not been properly installed or maintained, not properly fixed to the floor, contained a dangerous condition. And then that's just paragraph 41. There's other paragraphs. This is where I'm having a hard time when we say that there's been a total lack of failure to allege. And then I try to be cognizant of the fact that alternative issues alternate theory pleadings is permitted under Rule 1.100G. So trying to put all that together and looking at this, it may not be pretty, it may not be as clear, but does it state a cause of action?
And the trial court found that those allegations, those brief allegations, we have an allegation in paragraph 29 and 41, those are just basically saying Trench Training was negligent. That's essentially what it says. And it doesn't say much of anything more than that. And the pleading must be short and plain, but also state sufficient allegations of ultimate fact as to each element of negligence.
And so by improperly maintaining when there's holes in the turf that caused the injury, that factual allegation is deficient. The court found that was deficient.
The court must have found that the allegations in count 1 were deficient, and did, because the court specifically said that, and I can quote the court in the transcript, and your honors can read that, that it was conclusory and contradictory, I believe. I think one of the issues was that that, you know, you're in this count one stating that D1 and Powerhouse own and maintain both the premises and the facility, and then trying to also claim that Trench did that. And that's not in a separate count. It's not broken out into a different count. And that is one of the things the court actually began its focus. Even if Your Honor was to say, well, maybe they're close on alleging that there was some negligence, there's the background is very important, as brother counsel stated, which is that in dismissing the second amended complaint, the court gave specific instruction as to what it was looking at. And one of that was the fact that there were these multiple theories of liability, including vicarious liability and failure to warn, failure to maintain, failure to supervise, all these theories of negligence, failure to correct, and that kind of stuff. And it talked about purchased and for turf purchased and installed, obviously under paragraph 29 by D1 Sports Franchise LLC. So there's no explanation, for example, in there how these allegations, the various elements of these allegations. And in our brief, we've set forth how the court has held that in alleging vicarious liability, you have to set that out as a separate count. And the court the trial court had alleged that, or had instructed the defendant's counsel, who was different than the current counsel in the case, but the counsel who had handled the case for 3 years had instructed that counsel to amend and break out these different theories of liability. And the court even says in the transcript that, you know, that was not done. And so there, it was not, and the court said, you know, we're at some of the argument made at the hearing that Your Honors can see or indicate that, you know, what we're talking about is things that will be hashed out during discovery. And one of the court's comments was that, you know, we're 3 years into this litigation. We can't, I think the court's word were, you know, figure it out as we go along. That
But Mr. Husby, and well, let's just jump then to his other, in terms of whether or not by the court dismissing it, that the court should have allowed the amendment. And I've read to Mr. Tackenberg that in order for the court to basically refuse to permit an amendment, the court has to indicate that the privileged amendment has been abused, the amendment would be futile, or that the amendment would prejudice the other party.
Yes,
And
Your Honor,
so-
what the court was getting at, oh, I'm sorry, I did not mean to interrupt you, Your Honor.
No, and I was just getting to the fact that if you look at those three, none of these really apply because the trial court didn't find any of them. When you look at this claim itself, and I know you keep mentioning it's 3 times, but this specific claim has been amended only once against this defendant, as I review. Other amendments did not reach this one. And in terms of the amendment would not be futile, because if there's a defect in the existing complaint, it could be modified further to state a claim. And there's really no indication that this would prejudice, you know, your client's trial preparation. I know the only thing that brought up, this has gone long, it's a small business, 3 years is a long time, but for these things, you know, there's been no articulation by the court on any of these.
Well, Your Honor, I think that the court did allude to the fact that the case, it was late in the case for this to be occurring after three amendments, and the counts against Trench, I believe, were amended. The first amended complaint completely changed the allegations in the complaint against defendant Trench Training, radically changed. Then the second amended complaint also radically changed the allegations against defendant Trench. And the court, in dismissing that, gave specific instruction as to what to do to amend, and the defendant did not follow those instructions. And then I would say regarding the prejudice to the defendant, of course, we're very prejudiced because the plaintiff dragged its feet throughout the litigation prior to the dismissal. Defendant was I wouldn't say aggressively, but I would say promptly trying to do discovery in this case when it was allowed to do discovery. There was a scheduling order. There was a great effort taken to get the deposition scheduled of the plaintiff himself, which was coordinated, scheduled, noticed, and then unilaterally canceled by the plaintiff, who then wanted to take defendant's deposition, and then canceled that. And the issue is now, discovery is long gone, was long gone at the time. The scheduling order passed. The parties were referred to non-binding arbitration, which the plaintiff ignored. The order did not comply with that order. The defendants filed motions to dismiss, and it was essentially like pulling teeth to obtain dates for a hearing. The hearing on this motion to dismiss was delayed about 6 or 8 months because plaintiff's counsel at the time had indicated that they had no availability from approximately June until October, and refused to coordinate a hearing date. Finally, we were able to coordinate these hearing dates, and ultimately, as I said, there's the prejudice in the defense is that now we're years into the case. We tried and we're not able to get the deposition of the plaintiff. We're not able to obtain documentation of his injuries and those kinds of things. And now we've expired, so we could go back to the trial court.
And if I
And
may,
there's no schedule.
and if I may, because all of these things, we have to make sure that whatever you're articulating right now is in the record. And I think it was just glossed over. I think the judge just said this has just taken too long, given the amount of, the years. And to follow what Judge Labrie said, was under the gun because of the Supreme Court's administrative order to move the case along.
But it's not just that, Your Honor. I think that the fact that there was a scheduling order entered properly by the court, and defendant fully complied in good faith, and that the case is dismissed after discovery is closed. Now the possible prejudice is that defendant goes back to the trial court and is unable to undertake a defense at all, because we can't be assured that the schedule will be reinstituted, and that the time that has passed since is prejudicial to the defendant defending just by the mere nature of the passage of the time.
And was that all your arguments that you're mentioning, and was that all presented to the trial court?
Well, the difficulty with that, Your Honor, if you look at the transcript, is that the court did not ask for argument on those bases. We had argued only that the court should dismiss the case. Then the court went straight into the discussion of dismissal with or without prejudice, and articulated his own basis, and that basis is articulated in the last few pages of the transcript, where the judge explains why it is now time to end it. And I think what's implicit, at least in what the court said, was that we're under the Supreme Court order, which is why the court had entered a scheduling order to begin with, and entered the orders that it did, and that now we're past it, and we're past all that time. So this was not an issue where the plaintiff resolved the matter early on. And also, I think Your Honor should be very cautious about only relying on the issue of the with or without prejudice, because the issue here is the failure to properly state a cause of action is the primary issue, the first issue, and the court was very clear in its ruling about the commingling of the various theories, the various causes of action in one cause of action against the plaintiff, which it had instructed previously on the record in dismissing the second amended complaint should not be done. That included the vicarious liability and the other theories of liability. And then the contradictory allegations, which are contradictory. And
if you have a few minutes, Mr. Huck, because I know you keep mentioning contradictory.
Yes.
Zero in for me in the complaint. I have it right here in front of me, what specific things, if you have time, I don't know, Judge North,
Yeah,
if he
you're
doesn't,
basically, you're at your 20 minutes, but I'll let you.
then,
Judge
no,
Conrad.
there's no need. I could, no
Right.
worries. I don't want to
Okay,
take.
you need to
time
wrap
on
up,
that.
Mr. Husby.
Okay, I'm happy to do so, but if that's the end of my time, then I would just pray that the court affirm the dismissal entered by Judge Battles properly of the third amended complaint and affirm. Thank you.
Thank you. Mr. Tackenberg.
And unless the panel has any questions for me, I'm just going to hit a couple of points very quickly. Council takes issue with some of the statements regarding other entities in count one, in regard to, whether they possess the entirety of the gym. No one's disputing that the other entities possess the entirety of the gym. But of course, under this court's case law, more than one entity can control an area. And the case here is about who controls the AstroTurf. Who controls the AstroTurf? It doesn't matter if another entity simultaneously controls the gym. That has no bearing on this case. And of course, that comes directly from this court's decision in Metzger. There was an argument that the complaint was radically changed from the original to the amended to the verdict. The panel has the complaints. They allege the same premises liability claim throughout, and I will just rely on the record for that. I mean, to make a very logical argument, why would we have radically changed the first complaint when they answered it? They didn't even challenge it the first time. Why would we have radically changed it? That's just not true. And this is the first time I've heard this argument about scheduling depots and scheduling hearings. That wasn't in the briefing.
And let me interrupt you, Mr. Tuckman. That's why I asked Mr. Hugsby, was that in the record? Because we have the transcript before us, and this is the first time that I'm hearing that as well. So you don't need to go into that.
Okay, I will I will not go into that, Your Honor. With that, unless the panel has any questions, I would simply ask that the court reverse the order on appeal and allow the case to proceed on the third amended complaint, or alternatively, allow Mr. Thomas to amend. Thank you.
Thank you both.
Okay, thank you both very much. In order to leave our virtual courtroom, you should click the button on your Zoom screen that says leave. And then you'll leave. Okay, there you go. All right. Get myself organized here. The next case is Parker versus Parker.
Good morning.
Hi.